Okay, all my videos are basically just legal terms. The title is a legal term, and the video is just explaining to you what it means. And a lot of things I write, when I write complaints, I use these legal terms. One of them I use sometimes in closing statements. I will put in the interest of justice, which is a legal mandate. In the interest of justice, in the public interest, which is a legal mandate. It's mandatory for all public servants to do what's in the public interest. So I would say, in the interest of justice, in the public interest, justice must be served. It's a pretty good closing statement, depending on what you're using it on. But see, I was trying to. Some people get mad when I tell them to put their own magic on it. See, I just mix and match these words to say different things. And those are all the titles of my videos. Somebody called me a feminist because I was a strong, I always strongly advised, pushed for women's rights, but it was equal rights I was talking about, because the rule of law requires that nobody's above the law, you know. So even when the Constitution was originally written, the Declaration of Independence and the Constitution was put there that all men are created equal and endowed by their Creator with certain inalienable rights. Well, just putting all men are created equal, I mean, legally, if you go by the letter of the law, that's violating the rule of the law. So some of my videos I put to reiterate that by today's terms, in legal context, it would, if you apply letter of the law, it would legally have to say that all are created equal and endowed by their Creator with certain inalienable rights. Amongst these are, life, liberty, and pursuit of happiness, and that's one reason I found it objectionable to Roe versus Wade, because that's violating the rule of law. I mean, there's no laws that can be made in parochial interest, but they did it anyways. That's not in the public interest, but they did it anyways, It was a political ploy, well-known political ploy, and it was bragged about. And every judge will tell you, even tells you in the code of judicial conduct, that this political nonsense is, it's not supposed to present itself in a court of law. That's just crazy. But am I a feminist? I'm pro rule of law. That's all. So quit injecting your feelings. I prefer to stick to the law. Okay. So I'm not giving you my thoughts and feelings on any of this. I'm just giving you a legal perspective. That's all. All you have to do is look it up on the net. And that's what I do, is read these laws to you from the net. And you will find that in the interest of justice is mandatory, okay? And okay, so, but there's a lot of stuff on it. Okay, in the interest of justice is a fundamental legal principle allowing judges discretion to ensure fairness and equity, to ensure fairness and equity in decisions. Often invoked for dismissing charges, granting continuances, or ensuring proper legal aid, balancing individual rights with public good for a just outcome rather than with public good for a just outcome rather than strict legal technically alone. Its subjective standard guiding decisions whether to proceed with a case, modify penalties, ensure process, considering factors like fairness, necessity, and impact. Key applications: motion to dismiss. I've done that quite a few times, or had people do it, file motion to dismiss. A motion to vacate, motion to quash, Motion to dismiss. Judge can dismiss charges or enhancements if they're frivolous, unnecessary, or unfair, as seen the California Penal Code 1385. Also, frivolous cases are inadmissible in any court of law if you go follow the rules of professional conduct. You can't go in there with thoughts and feelings and Facebook memes. You will lose. And I don't know why any judge would allow anybody to go forward there, because that's violating the rules of professional conduct. Why would somebody knowingly and willingly violate the rules of law, the court of law, and present a fraudulent and frivolous case? Why would any judge allow them to do it? Why would they allow somebody else to have to hire a lawyer to argue this? That's deprivation of rights. That's not in the public interest. Okay. Criminal proceedings, courts might consider factors like the crime's nature, evidence, defendant's record, the public impact before deciding on prosecution. Right to counsel. Right to counsel. This is very important. Right to counsel. International law suggests a right to legal aid in civil cases to ensure fairness, supporting this principle. Okay, so because the only way you'll ever see a fair trial is if you have effective assistance of counsel. Effective assistance of counsel requirements are in the rule of professional conduct and the code of judicial conduct, and nobody's doing that. So I mean, how can they ensure any fairness? They never attempt to get informed consent from you. They just proceed without any regard to your consent. And that takes reasonable knowledge to make an informed decision, to give that informed consent. And if you go through all my videos, you'll find that you need the legal knowledge. You need, of those you're up against. Legal knowledge to make an informed decision, to give informed consent, is what you need. Prosecutorial discretion. Prosecutors and international bodies like ICC use decide whether to investigate or prosecute, considering public interest and resource allocation. Core idea, fairness over form. It prioritizes equitable outcomes over rigid adherences to rules, ensuring the legal process serves justice, not just procedure. Judicial discretion grants judges the power to look beyond strict legal arguments to achieve a just result. Public and private good balances the rights, needs of the parties involved with broader social interest. Essentially, when a judge acts in the interest of justice, they're ensuring the system delivers a fair and righteous result for everyone involved, even if it means bending strict procedures. Okay, but nobody can violate the rules of the codes. So there's no bending. No breaking, there's no bending, there's a strict adherence according to the letter of the law. So that makes any law you read, anything that I read to you, when you look it up yourself, it makes it self-explanatory, because according to the letter of the law, you got to do that word for word to the letter. And describing it in any other manner than what is written is disinformation. There's penalties for violating the letter of the law, penalties for disinformation. Okay, so this is just a short one. In the interest of justice, there's a lot more to be said about that. Okay. I've used this before. Not in the interest of justice. Simply put, in California, judges have wide discretion to dismiss specific charges or criminal enhancements if find them to be unfair, unnecessary, or frivolous. Essentially, they can dismiss charges and enhancements in the interest of justice. This power is provided to judges under penal code. I've helped a lot of people with, in criminal cases with probable cause hearings, because when they ask for a probable cause, public defender gets mad. The judge ain't gonna like that. The state's attorney ain't gonna like that. They come back with the state's attorney and offer you a plea deal, and if you don't, they're gonna throw more charges on you. Well, that's not in the interest of justice. That's literally violating the double jeopardy clause. You cannot charge a person multiple times for the same crime. And I will bring that up to the judge, when we approach the bench. So usually that gets, they offer a probable cause hearing and throw it out. So you only have to go that one day. They don't continue it, and sometimes I get there too late for people when their case is already, no probable cause hearing, so they send it off for a preliminary hearing and then a trial, and they spend months trying to convince you just to take the plea deal. Maybe a year, 2 years if you're locked up. Sometimes I seen this guy locked up over 2 years waiting on a trial, and that's exceeding quick and speedy trial mandates. So his case could have been thrown out on that, just on that alone. Violating that quick and speedy. So wherever you're at, look it up. Quick and speedy trial. That rarely happens, and definitely not in the interest of justice. Okay, so there's a lot of laws you can use. You just got to look at my videos, and those are laws. And you can look it up yourself and read it to yourself or watch the video, and that'll tell you what it means. Okay, so there's a combination of laws you could put together, and if you read any of the stuff I put for complaints, it's just combining those laws, that's all. They're just words. What's the hardest case to win in court? It's not that hard because nobody's using the rules or the codes or abiding by them or enforcing them or reporting any violations, any misconduct, and reporting misconduct is mandatory. So it's not that hard to win any case in any court of law if you use the rules and the codes. Because your lawyer not addressing the rules with you and the codes, and reviewing with you and letting you know the legal system's legal obligations to you in its entirety. Not just them, but the opposing party, the judge, and there's a lot of things that they won't do if you don't know. So it starts with your lawyer. And him not doing what I'm talking to you about. It says in the rules we're supposed to educate the public. So that's what I'm doing. I'm doing my best. I'm not a lawyer and I'm not in public service, but when I took the Pledge of Allegiance, it was to you, we the people. But no matter what court you're in, the rules of professional conduct and the code of judicial conduct are the common denominator in every court of law. They're the key factor in every court of law. What's the hardest case to win in a court of law? Court often involve cases against minors, first-degree murder due to premeditation, complex white-collar crimes because extreme emotional bias, high stakes, expensive financial evidence. Okay. in the best interest of justice means. So there's the reason for case dismissal used when a judge decides justice will be best served when a case is dismissed. You know, deprivation of rights. Deprivation of rights, when you charge your attorney, you not only charge your attorney, you charge the opposing party and the judge as well for deprivation of rights, considering the fact that reporting misconduct is mandatory, violating the rules or the codes. Violating any rules or codes, that's misconduct, and reporting is misconduct is mandatory in both the rules and the codes, and nobody is doing that. That's a conspiracy where two or more people work together to deprive you of your constitutional rights to, due process, a fair trial, quick and speedy trial, effective assistance of counsel. Okay, so that's a good reason for a dismissal, okay? The best interest of justice. Unfair dismissal, when an employer terminates employment without a fair reason. Constructive dismissal, when an employee resigns due to employer fundamentally breaching the contract. And wrongful dismissal, when a terminations breaches contractual terms, usually regarding notice. Don't lie or exaggerate the facts. Yeah, don't ever do that. Just stick to the truth. It's always easy to remember. That's where I've helped with people in a lot of criminal cases. It's rare that anybody can testify to any of the statements they gave on previous occasions. See, that's where disclosure comes in. Disclosure is mandatory, but they don't do it. In discovery, every time I ask for discovery or anybody asks for discovery, what do you want? What do you need it for? Well, it's important. It's important because people will say things that they can't prove. And the only way you can do that is if you have discovery. So you'll know what they're going to say or what they're going to testify to, or in court and to in court. If there's any hospitalization, people have a tendency to exaggerate what they were treated for, and the complications afterwards. So it's disclosure is important, full disclosure. But I've never experienced that with my own attorneys, and a lot of people have told me the same. Fail to disclose. That's against the law. See, so you're actually working against your own attorney because this is the one that starts this conspiracy against rights with deprivation of rights, but not by not assuring you effective assistance of counsel. That's living up to the oath. That's part of what his oath requires. Remember, all lawyers, no matter who they work for, no matter what side of the table they're on, no matter what courtroom they're in, they're required to do what's in the public interest. So if their employer expects them to do something that's not in the public interest, well, that's breaking the law. They say, hey, no, that's not in the public interest. That's actually far from being in the public interest. Yeah, but it'll make us money. Well, see, we'll be breaking law. I could lose my license to practice law. That would be violating the oath. You know what the penalties are violating the oath, And then I'm going to have to say something and put it on paper, that'll make it look plausible, And that's disinformation, Then I'll have to get the judge in on it, and then the opposing party. And so, it's very complicated for them. But it's easy for you if you read the rules and the code to say, hey, nobody's doing none of that. You know, people, they get upset with me, they get angry with me. I've had people yell at me, well, they know that's their job. Why ain't they doing it? Well, why are you telling me? Why don't you go tell them? So, I'm just trying to help, trying to get you to understand what you're dealing with, what you're up against. And people are starting to recognize that I've been helping, that I've been warning. I warn people forever and talk about the nepotism within the legal system. There's a vast amount of nepotism in there. And they're just starting putting it together, and I don't, even if they know, if they recall me mentioning on numerous occasions in different videos about nepotism in the legal system. Okay, folks, that's just, how would you say, a snowflake in a storm. Be a little kid, let this be your first snow, and just run out there and jump in the snow. And this is one of many videos I've done. And if you don't want to watch the video, just look at the title and say, oh, hey, that's a legal term. Let me look it up myself. And, people say, do your research. Well, I don't like fact checkers. Well, I mean, it's just, come on, people. This is the law. These are your rights. They took the oath to do that. So these are contractual obligations. Okay, simple as that. These are the requirements of the oath. Everything I talk about, those are requirements of the oath. So for just violating the oath alone, there's penalties for it. And then if they're doing that, then they're not doing all this other stuff I'm talking to you about in all my videos. Because all that stuff is required by the oath of so many of your public servants, and not many of them are doing it. Some politicians are trying. I've been reading about some cases where lawyers are actually trying. This one state's attorney was trying to overturn a wrongful conviction. I felt rather proud to be American, because he was doing his job. It's the state's attorney's job to overturn a wrongful conviction if they become aware that it was a wrongful conviction. That's their job. And especially if it's in their own jurisdiction, their own district. They become aware that if anybody, is innocent of a case that they were found guilty of, it's their job to remedy that. Rule 3.8, special responsibilities of a prosecutor and the rules of professional conduct will tell you that. Okay? So, in the interest of justice, people, all right, this is why I do this. In the public interest. Well, I've been a fan of We the People since I read the Constitution back in 71. That's who I took a pledge of allegiance to. We the people. So when it comes to the We the People, the Constitution, I don't just have it in my head, I have it in my heart. That's what makes me good at what I do. Okay. And I don't try to use these big fancy words to make you feel stupid. That's just stupid. Plus, there's none of them big fancy words in all the laws I read you, so it's not that complicated. Remember, the letter of law makes it self-explanatory. There's penalties for violating the letter of law, and when you violate the letter of law, that's disinformation. There's penalties for disinformation. That's violating the oath. Penalties for violating the oath, and that's just being a dickhead. All right. So, hey, people, if you want them to do their job, you got to know what their job is before they'll do it. Otherwise, they ain't going to do it. And they're just going to go back and forth and, not really do nothing, I mean, every time I go to court, there's only a couple hours only spent in court. The actual day, the whole day, where something actually goes on. And shortly after lunch, it's over. You're late starting court. Go to lunch early. Day ends early. Oh man, it's ridiculous. And that's because justice, as we well know, is on a monetary scale. And the only way you're going to stop that is, acquaint yourself with the law. And I'm showing you a lot of them that nobody's abiding by, so use those to start off with. I spent a lot of time in books years ago. And that's what got me into getting a computer and teaching myself how to do that thing and expose myself to the internet and find all this stuff on the internet. I think everything's getting easier because I can't get up and move around too much, and I'm doing this on my phone. I'm old. I'm handicapped. Stuck in this chair for a little bit until I can manage to make it over to the couch and then to the next couch. It's not a handicap-friendly place. I use canes, bilateral forearm crutches, wheelchairs. But that's something isn't necessary to discuss. It's what's going on in your life, people. Okay, I'm just worried about what's going on. You know what happened to me? There's nothing going back and changing that. Nothing stopping it. But what stopped it was what I knew. And that's where this comes in. It's, if I can read this, remember it, and it's easier even now. You got the internet to carry it. You don't have to go, you don't have to spend as much time as I did in the law library. And, sometimes I read something in the papers, magazines, see it on news. I had to find out. I had to figure it out. To me, when it comes to the law, there's always a need to know, and you could always look it up on the internet now, and that's what I'm encouraging mostly. The public interest, in your interest. If you want to see everything that's done is done in the interest of justice. You're going to have to learn all this stuff. I hate to be the bearer of bad tidings, but if you don't, like I said, scale of justice on a monetary scale, and if you ain't got the gold, you put on that scale, you get sold into indentured servitude, in debt for the rest of your life. It's the legal system and all its ill-gotten gains. Alright, people, I just wanted to give you something to think about. Remember, doing what's in the interest of justice is a legal mandate. It's in the public interest, which is in the legal mandate. They took the oath to do this, which is a legal mandate. It's been codified in the 5th, 6th Amendment, the 14th Amendment, due process clause. Due process. So, people, these are your rights. All right, you have a good night. Nothing but peace and love. World of happiness for you. May your Creator always be with you and rain many blessings. Here's to your long life and good health. Good night.